Surely. Well, good evening, everyone. Thank you so much for coming. This is the very first time we are doing the Constitutional Connections seminar. Every couple of years we do the personal finance, but this year is the 250th anniversary of our Declaration of Independence. And of course, we have to celebrate that. Students talk about it all the time. We have been discussing various aspects of civil discourse. Every single day, that's a big topic of discussion in the classroom and elsewhere. And at Brookfield Academy, of course, we try to always enforce that. So that's where the seminar comes in. And when I started thinking about this a few months back, these 5 wonderful panelists immediately came to my mind. And luckily, they all accepted the invitation. So the way we're going to take it today, I have 3 of my government and politics students out here, Marilee, Amina, and Zosia. So I'm going to be handing over the mic to them, and they are going to be leading us through the topic and introducing the panelists, and then bringing out the questions and timing them and moderating them.
And grading? I hope not.
So, no, but this is going to be a lot of fun, and luckily we are able to record it, so we have, and now they're recording the whole proceeding. Perfect. So with that, I'm going to hand it over to Marilee.
Good evening, everyone. On July 4th, 2026, the United States will commemorate one of the most significant milestones in its history, 250 years since the signing of the Declaration of Independence. This anniversary is more than a celebration of the nation's founding. It is an opportunity to reflect on the principles that have defined the American experiment since 1776. The Declaration of Independence articulated a bold version of liberty, equality, and self-government. In the years that followed, the Constitution and its amendments established the framework through which those ideals would be debated, protected, and expanded. Together, these founding documents have shaped the nation's understanding of civil rights, civil liberties, and the responsibilities of citizenship. As we approach this historic anniversary, it is fitting that we pause to consider how these principles continue to influence American life today. The purpose of this panel is to reflect on the enduring ideas expressed in the Declaration of Independence and the Constitution, to examine how they have guided and at times challenged our civil discourse across generations. By exploring the balance between liberty and order, the responsibilities that accompany free expression, and the evolving interpretation of constitutional rights, we hope to gain a deeper understanding not only of where our democratic traditions began, but also how they continue to shape us, who we are as a nation today. To help us explore and better understand these important ideas in a modern context, we are fortunate to have with us a distinguished panel of lawyers and academics whose perspectives and expertise will help guide this discussion. I want to take a little bit of time to introduce our 5 panelists as well. With us today, we have Cynthia Davis, who is a judge for the 21st branch of the Milwaukee County Circuit Court and is also a BA alum. Timothy Moore is a Deputy Director for Outreach and Professional Development at the Center for the Study of the American Constitution at the University of Wisconsin. Melissa Koenig, Professor of Law at Marquette University and a former BA parent. Kenneth Dortzbach, he practiced law privately and as in-house counsel in various countries. He's a former adjunct law faculty at Marquette University and published a law review article about statutory interpretation by the U.S. Supreme Court, and a former BA parent.
And mock trial coach. Right?
Oh, mock trial. And James Santelle, a criminal prosecutor and civil litigator with the United States Department of Justice, including over 6 years as the United States Attorney for the Eastern District of Wisconsin. Before we begin, we just have some ground rules. We have 6 questions total, and there's 10 minutes for response for each question. Amina will ask the questions, we will time it out, and everyone is invited to answer and participate. Thank you. Amina?
Thank you, everyone, for being here. The first question is, as the United States approaches 250 years since the signing of the Declaration of Independence, do you believe the ideals of liberty and equality expressed in that document remain as strong today as they were in 1776? And where do we see them upheld or strained in modern civil discourse?
Who wants to go first?
Well, I'll go first so you don't steal any of my answers. So we did have the luxury of having the questions sent to us before. So it was very, very kind that we had some time to think about these very well thought out questions, but they do make you think a lot. And to answer the question directly, I think we certainly have come a very long way since 250 years ago. We've made a lot of strides, and as a woman myself, I appreciate certainly the strides that have been made toward guaranteeing equality for women, the right to vote. You know, we think back to the signing of the Declaration of Independence, the author, Thomas Jefferson, right? He espoused these ideals, but he owned slaves, as well as a majority of the founding fathers. And so we have the abolition of slavery. We have the right to vote now for all, regardless of race. And so, yes, a lot of strides. My concern, though, is any time that, and we see this throughout history, we have period of freedom, but then we have instances where our security is in jeopardy, whether that's national security, think 9/11, or our health, the pandemic. And it's always interesting to observe how quickly that we as a society will turn in our freedoms for that guarantee of security. And so you see the pendulum kind of swing back and forth. You know, I was trying to think of examples, one before my time. You know, World War II, we interned Japanese Americans. We were fearful. The response to 9/11, we had the Patriots Act that guaranteed a lot of national security. It gave law enforcement the right to, investigate very freely. But a lot of those provisions were ultimately deemed unconstitutional, violation of the Fourth Amendment. And you think of COVID and the ways in which that we as a society were trading in our freedoms. And I think about the vaccine and the vaccine mandate, and at one point, just considering individuals who were going to have to choose between their career and livelihood and getting a vaccine. So, and I know that might be a controversial topic, but that's my concern, that we always have to be vigilant about trading in freedoms for security. I don't know who's the next.
I have thoughts. I was going to say briefly, we clearly, obviously, when the country was founded, slavery was legal, women's rights didn't really exist, and objectively, we've come really far from them. But in other ways, we haven't necessarily done that. So for example, the top civil rights attorney in the country is the Assistant Attorney General for Civil Rights of the Civil Rights Division in the Department of Justice. Her name today is Harmeet Dillon. She's Sikh. She was born in India, and she grew up in a town in North Carolina in the 1970s and 1980s where they had the Ku Klux Klan. Every single member of her family learned how to fire a gun, okay? Now she's, as I said, she's the top civil rights attorney in the country, and she's trying to protect civil rights for everybody and every civil right. And she filed suit last September against the Los Angeles County Sheriff's Department because they were taking over 3 years to process conceal and carry permits, okay, when it should take days. So clearly, she's going to win that suit. So there are things like that that are happening. Also, when you look across the width and breadth of our history, one of the biggest changes that I found interesting is in the 1930s, how our view of the Constitution fundamentally changed in two major ways. In one, federal government started getting much greater, and a lot of the power of the federal government was given to unelected officials. And that continued largely unabated for decades. It's starting to swing back the other way, but that's one of the huge debates that's going back and forth in our country, and we're not going to solve that anytime soon.
I'm going to be contrarian here.
Great. I love it. You're Constitution?
I'm going to take,
Okay.
when I read this is a fantastic question, but it's kind of sleight of hand, because I think I don't see the Declaration as having much commitment to equality. I think, well, first of all, the first two paragraphs are philosophical. To me, the most important parts of the Declaration were the list of 28 grievances. And that, and all the lawyers here would, I think, they love that, those 28 grievances, because it's very legal. The first two paragraphs are philosophical, and equality appears in the philosophical section. And it says we're equal pre-social contract. So I don't know that the Declaration is a great spot to argue for equality. I know how you can get there, but it seems to me that the Declaration does a much better job. The legacy of the Declaration, the first two paragraphs, is much more traceable when we talk about liberty, especially if we're defining liberty as property. Because I think the first 100 years of our history, we did a great job at that. I would say that the commitment to equality starts in the 14th Amendment, where there's a clear statement of a commitment to equality, and that created a whole lot of tension in the civil discourse about what that meant. So I think it's, I'm just pushing back on, I'm not sure the Declaration is the best spot to go for our commitment to equality. I would say that comes in the 1860s, and we've wrestled with the meaning of that equality ever since. Some civil discourse about the meaning of that, and some uncivil discourse about the meaning of that. I do believe there is a principle of equality in the Declaration, and the principle of equality in the Declaration is the last paragraph, when states are seen and defined as equal. It says they're separate and equal. So that's past the first two paragraphs. So I think there is a principle of equality there, but oddly enough, it's called federalism. The commitment to federalism, I think, the unresolved commitment to federalism, because other parts of the Declaration it talks about us being one thing. The last paragraph talks about us being 13 separate things. So I'm just pushing back a little bit on the Declaration being the be-all, end-all for liberty and equality, if that makes sense.
I'll go from there. I think it's a nice dovetail. So I teach legal writing at Marquette Law School, and I work with first-year students a lot and try to give them good metaphors. And before that, I actually was a high school English teacher before I went to law school. So I'm going to try and give you some metaphors and some things to walk away with that you can read or think about. And dovetailing from what you were just saying, in 1861, Abraham Lincoln, who was under a lot of strain, wrote a private note to himself. And you may actually have studied this already if you're here at Brookfield Academy. But he wrote this note to himself, and it's a great metaphor of the relationship between the Constitution and the Declaration of Independence. And that is a golden apple, which you can look at as the structure of government in the United States, or you can look at it as the Declaration of Independence, because actually Abraham Lincoln at that time viewed the Declaration of Independence as really the perfect document. And then the frame around it is, there's a silver picture frame around this golden apple, and that is the Constitution. And so people have used that metaphor over the, many years that we've had it since 1861 to really think about the importance of the Constitution in protecting those ideals of liberty and equality that we've been talking about. So I just wanted to share that with you. And in terms of future reading, and if you've gone to BA, I think you've already read this too, but it's worth really rereading the Gettysburg Address and thinking about what Abraham Lincoln was considering as he was facing strained civil discourse at that time. And I guess my answer to your question about our modern era is that I think that those two documents in tandem have served us very well through many crises. And you can look at our society today as having new strains I think we'll talk later about technology being one of them that constrain our civil discourse. But I do think that the golden apple with the silver frame should be something that we consider.
My thought on the first question, again, focuses on liberty and equality and how we define those. It's also the year in which we celebrate the 238th anniversary of our Constitution. As a former federal prosecutor, I will tell you that every single day of the week, we invoked principally the amendments, but other language in the Constitution when it comes to executing search warrants and issuing subpoenas and having trials in front of judges, witnesses, all kinds of things. And there are times when we used to do that where we'd also go back to the Declaration of Independence and talk about the same genesis of those principles that come into the Constitution in more reality. The second point that I would make is just this. As the judge just said, we have had 250 years of history. Things have changed a lot, and I think we'll get to that later on when it comes to interpreting the Constitution and how, again, today, if I can anticipate that a bit, if James Madison were here today, he would not know what that is. He would not understand what this is. He would not understand how any of us got here in cars, how Ken is going to go on this thing called an airplane tomorrow and get there. None of this would be familiar to him, and we'll talk more about that. But it underscores the importance of the fundamental principles, liberty and equality, coming from the Declaration, and then given some livelihood in the Constitution. My second point after that digression is simply this, that depending upon the time and depending upon the human being, we've talked about this a lot, the concept of sustainability. How do we sustain those principles over time? And how do we make them alive from person to person? When you get together plainly and talk about these issues, the person to your left and to your right is probably going to have a slightly different view of what those are. That has always been, I suspect, the case in America. I think it's especially true today as we read more literature. We're exposed to more of the history. We're exposed to more of the commentary that is out there. And the great concern and the strong takeaway that I derive from that very good question is that issue of sustainability. From the Declaration through the Constitution, what about the next generations and the generations after you? How do you sustain some fundamental concepts to which we remain true even in times of crisis, economic crisis, wars, other challenges we're going to continue to face throughout the next 250 years of our country?
Thank you guys for that. The next question is, the framers of the United States Constitution believed open debate was essential to a functioning republic. What standards of civil discourse do they expect citizens to uphold, and how closely does today's political culture reflect those same expectations?
Whoa. Want to lead us off again?
I'm happy to. So the thought that I had after reflecting upon this question was a quote by Thomas Jefferson, and it's included actually in our statement here at Brookfield Academy on politics at Brookfield Academy. And I just like it a lot because it's something that I espouse myself and a belief that I have. And it's the statement somewhere along the lines of, I've never found that a disagreement in opinion regarding politics, religion, etc. should be cause for withdrawing from a friend. And so this was in a letter that Thomas Jefferson wrote to a political opponent. And I appreciate that concept because we have to be in a society where we are able to have vigorous debate with each other, agree to disagree, but not engage in, and this is to honor Mrs. Pryor in Latin, those ad hominem attacks, right? The attacks against the person, which we learn in law school. If you're going to lower yourself, right, in a brief or an argument before the judge to attacking the character, the personality of the lawyer, that means that you're, taking the low road. You are not equipped to actually address the argument. And I think, unfortunately, right, in today's culture with social media, we can hide behind social media. We are not having to engage in that vigorous debate because we can just, with one-off statement, say something in a comment that we otherwise would not probably say to someone's face. So I think we've digressed a lot in that regard. And I think about Supreme Court justices, both deceased now, but Antonin Scalia, Ruth Bader Ginsburg, both great legal minds on different ends of the political spectrum, and they are known for their friendship and their ability to attack each other's arguments in their written opinions, but then at the end of the day, go out and have dinner together and be friends. And unfortunately, I feel like along political lines, that's just not something that's even allowed or respected anymore. And I think we need to get back to that.
I'll offer up a one-word answer to the second question, and then I'm going to speak longer, obviously, right? Lawyers, right? Unbound. I wrote down the word work, that public discourse should be a lot of work. I was telling my colleagues here, I brought along some props. Here's the Federalist Papers. Don't worry, we're not going to be reading from it tonight, right, Melissa? But this is a lot of work. This was advocacy by, yes, Alexander Hamilton and James Madison, John Jay, and the advocacy was to people in New York, principally, for the passage of this thing called the Constitution. It is very difficult to get through today in today's language, but look at all the writing, look at all the work that the three of them put into doing this thing that they felt so important to the future of the nation. The words, the thoughts, they divided them up into subjects. They said, this is the reason why this particular component of the Constitution makes sense to you in New York, and frankly to the rest of the colonies and the emerging states at that time as well. This is a lot of work. And I think that the lesson set by, again, Hamilton and the others is one that is important to public discourse today. If you are going to be deriving all of your information from those easy social media sources, you're not doing the work to make it important. And it's easily recognized, of course, by people who say, oh yeah, that's just that post or that phrase that's very common out there. I think that those people are successful today in arguing the major issues of the day, whether they're economic, agriculture, academic, social, all kinds of things, cultural issues. The nature of what government should be doing are the people who are spending some time getting to know what the issues are all about. I refer to them often as the people who know what they're talking about. And the one concern that I have, not political at all, is the sometimes retreat into easy answers and to reliance upon people in all sorts of areas, specifically science and yes, academics, who know what they're talking about, and those who do not know what they're talking about have not done the work to engage with the people who do. And that's the concern, I think, about the discourse today, educating ourselves, challenging ourselves to do the work, maybe, Jim, not entering that conversation if you know nothing about it, and going and studying up, and then doing the kind of thing that Alexander Hamilton did in putting together the work to make this thing happen.
That was really beautiful, Jim. Thank you. Well, I wanted to highlight the idea of, okay, how would the founders, how would they want us to approach the problems of today and our political culture? And that I just wrote down a few notes about that. That Jefferson and Washington emphasized national harmony and mutual respect. Jefferson actually called this social love, which I like because my last name is partially love, which he said was essential for liberty. So social love is essential for liberty. And they actually emphasized that unity does not mean uniformity. It also means diversity. And I think that is something that we really can get around these days, because we do have a very diverse population in every single metric in the United States. And our founders found diversity to be a strength that could be something that unified us. And I have a Jefferson quote too, It's somewhat similar to yours, Judge Davis. Every difference of opinion is not a difference of principle. So every difference of opinion is not a difference of principle. And then finally, that Jefferson, Madison, and Washington wanted an educated public. So here we are at a school that strives very hard to educate its students and families, and that active participation and critical thinking are important. So I think if we put that all together, we can see that it's really important to walk across the aisle and talk to people who have differences of opinion. And I do worry right now, to your point about social media, that we're not necessarily talking across the aisle as much as we should be. And I think the founders really want us to go back to that.
Okay, I do not have a Thomas Jefferson quote, but that was.
That's okay.
I will be brief on this one. When I was looking at part of the question, what I focused on in my particular case was what standards of civil discourse do they expect citizens to hold, and do we do that now? And that's kind of interesting because we have this wonderful view of the old days back in 1776 and how this all came down. And I don't know, now, some of you might have read a number of historical novels to learn about the period, and some of you maybe went to the musical Hamilton. The musical Hamilton is probably pretty close to the truth. Civil discourse back then was a verbal and written food fight. It was a free-for-all. And while they wrote wonderful standards, and they did try to live up to them, and it's important to try to adhere to that, in reality, they didn't follow them. And we don't really follow them today, but in a sense, I'm not so worried because, I mean, that's kind of how we've gotten here, and we've never really had that moment where there's civil debate. So I think we'll be okay, but I do think that with the Federalist Papers and some of the other things, they give us something to aspire to, even if they went well below the bar.
I'd like to read some of the things that the founders said about other founders.
We didn't set this up, by the way.
I guess this is contrarian. This is contrarian corner. My opponents are wretched. They deserve not to live within this country. Vile enemies, babbling. Federal soldiers fixed with bayonets will soon give such daring dogs their quietus. What a glorious day would come. They're tyrants. They are a disgrace to human nature, composed of an empress lordlings, sounding thousands of bloodsuckers, cringing sycophants. The army is made up of idle ruffians, delusional falsehoods, suppression of information and fraud. There was a problem with the post office circulation back in the day. And the Anti-Federalists thought that the Federalists were controlling the media. So this is all about, controlling their instruments of information. The pillars of tyranny have been raised in their newspapers. Men of great learning and eloquence and sophisticated sophistry in the shape of lawyers and doctors.
Easy, cowboy, easy. We were together for a while there. Now I don't know.
Now, those were the Anti-Federalists talking about their founder colleagues that were in favor of the Constitution. Well, here's some Federalists attacking Anti-Federalists. Virulent spirits, malignity which reigns within them, poisoning, disseminating discord and uneasiness, venomous vipers hugged in your bosom, they will eat your bowels and prey upon your very vitals. They will sap the national security and happiness. The lawless, disobedient, licentious. One of my, I got a lot of this. One of my favorites was, it's a satire piece, actually. And the satire is spoofing and making fun of how Anti-Federalists recruited people to their cause. And so the recruitment pitch was, gather ye insurgents, rioters, and deserters, Tories, refugees, stupid, dunderheaded, blunderheaded, muddle-headed, puddle-headed, blockheads, tribe of sniveling, driveling, sneaking, slinking, mopping, poking, mumping, pitiful, pimping, pettifogging, poltrons, set of nincompoops, ninny hammers, mushrooms, jackasses, jackanapes, goose caps, shit pokes, and I'm not gonna say that. So these are founders. And they're engaged in, I think it's the most important debate in our history, that 2.5-year window of time when states are deciding whether they want to have the Constitution or not. This is what appears in newspapers. And by the way, they're all pseudonymous. There's a reason they write pseudonym. I would push back a little. It's not Jay and Hamilton and Madison writing. It's Publius. And there's a reason in this era, there's a reason they use pseudonyms. This is the era of dueling. All you have to do is go to the Hamilton play to see that. So I'll push back. I'm not sure we ever had civil discourse. Now, the elites, even the elites at the convention had these rules. And if you ran afoul of the rules, the man would look at you from the chair. Washington would. And so they knew themselves to be men of little faith towards each other. I mean, there's just some remarkable things in their private letters of what they thought of each other, and they're not flattering. So, like you, I think we've kind of inherited this uncivil discourse, and I think the revolution really starts it. Some of the things that are written in the revolution, quite remarkably ugly. Towards neighbors. I mean, Patriots, Tories, it divided people very, very, very virulently. And that continues into ratification. So, like you, I see a lot of junk, but the 1850s, Joanne Freeman just wrote a book, Field of Blood. It's about how ugly Congress was in the 1850s. There were duels, beatings, canings, almost every week on the floor of Congress. So I'm not clutching my pearls quite yet on our lack of civil discourse, because I see us never really have. And these are the elites talking about other elites. So I guess I'm not quite alarmist yet. I mean, there's some ugly stuff out there. When we start to see violence, that in the last year or so, I'm maybe forced to rethink my position on this. But I'm in your corner on this one.
All right, we're still together.
Well, and I just want to add something to that I think what you're saying, correct me if I'm wrong though, is that human nature is human nature, and it was human nature to argue and debate and fight in 1776, and it's true in 2026 as well. And hopefully, I think, my feeling on it is that the Constitution, the Declaration of Independence, the safeguards and the rights and privileges and responsibilities that we have been given are hopefully enough to keep us together. And actually just wanted to say my little reading for you, if you haven't already read it, is George Washington's farewell address. It's just 2 pages and fantastic.
Okay, now for the next question. The First Amendment of the United States Constitution protects free speech, but it does not guarantee constructive dialogue. What responsibilities should accompany that freedom if a democracy is to remain healthy? I see that we've kind of already touched on this, but I'll open the floor.
Well, I have thoughts.
Go.
By the way, if I seem on edge tonight, it's because I paid my taxes this morning. It's true. It's a true story. So I'd still it hurts. It does. It does a lot. It left a mark. So here,
Congratulate, taxes are the price we pay for a free and independent and viable society.
yeah, whatever.
Right?
Okay. All right. All right. Limitations on free speech. Or at least, do we need to have do we need to do something to have a constructive dialogue? And I would say absolutely not. we should do nothing. And to go along that lines, I think the United States is literally the only country in the world that protects free speech, and that includes Europe and Canada. And while you could write an entire book on the topic, really, since I have about 60 seconds, I could boil it down to one thing, and it's the criminalization or otherwise punishment of hate speech. Because somebody has to define hate speech, and there we go. So just briefly, like the country that we got our liberty from 250 years ago, Great Britain, they have hate speech laws. They just passed in 2023 a new online hate speech law. And I think they average about 12,000 arrests a year for violating this and about an 85% conviction rate. And in the meantime, the top justice official in Great Britain, David Lammy, recently proposed doing away with jury trials for any for any crime that has 3 or fewer years of prison. So he calls them swift courts, which sounds kind of fun, doesn't it? So you could literally, if you post something online and you make the wrong person angry, or get reported to the police, one judge could charge you, sentence you, there you go. Canada, literally 2 weeks ago, tightened up their hate crimes law, C9 they called it, and they did away with the religious good faith exemption. So that makes things tighter. And meanwhile, take a look at Germany. So they have criminalized pro-Nazi speech. Okay, now I don't know if any of you are history buffs, but the Germans had some problems a while ago with the Nazis. So I get it. But also, if you see, it hasn't helped because there are a lot of neo-Nazis in some of the eastern regions, and it's a problem. I have to say, now, I hate Nazis, okay? But most Nazis are stupid, and others, the rest of them, are foolish. But one thing I can tell you that's interesting is the more they talk, the more they reveal how stupid and foolish they are. So I think, in many cases, let the people talk, and they're going to reveal how bad and how stupid they are, and I let them at it.
I'm going to push back now.
This will be good.
Yeah, I'm not that confident.
People who support free speech support free speech.
Yes.
There's no if, and, or buts.
Correct.
Okay.
I think when the Constitution and Bill of Rights was written, there was an assumption of reason and rationality. It's an Enlightenment era document. One of the basic assumptions of the Enlightenment is reason, rationality. I believe we are in what's now called a postmodern world. The postmodern philosophy, I'm trying to be generous to it, does not assume reason and rationality the way the Enlightenment era did. So I wonder if in the airing of opinions, which I'm generally on board with, but I don't know the world in which we live now will entertain rational thinking and rational discourse about your Nazi speech. So if you run this postmodern idea out, I don't know, speech may be irrelevant actually in a postmodern world because there's no basis of communication and common understanding. So I don't know that the postmodern world of no reason and rational thought or discourse, I see a problem in that world with the free market of ideas. I think what I hear you saying, the free market of ideas to put
Takes
that
care
out
of
there.
itself.
Yeah. I don't know if that works in a postmodern world. I mean, I don't know. We're kind of in the front end of this. If I knew that, I'd be on the circuit making, I'd be on this.
All right, well, let's see how the rest of the panel feels about the First Amendment.
I'm in favor of the First Amendment.
Right.
So like a good student, went to the First Amendment. It's very brief, as we all know, and it says Congress does nothing when it comes to religion, free exercise, and establishment, nothing to abridge the freedom of speech, the press, and to peaceably assemble, to petition your government. It's all right there. And when I saw this question, this wonderful question, the word that came to my mind, once again, the single word was enforcement. There it is on the page. How do we get to that? And the answer, at the risk of coming up to my good colleague here, a judge, is through judicial process. If you are unhappy with what the government is doing, if in fact, as it has been interpreted, Congress, more broadly the government, that was done by judges who said, we're going to interpret this. There was a trial just a couple of weeks ago in California, the Superior Court in Los Angeles, where these issues about freedom of speech and the capacity of an online platform to affect people and to have an influence upon our lives, very much at issue, presided over by a judge. Yes, there was a jury there. But the point I wanted to make is the importance of the judicial function. It is Article 3 in the core text of the Constitution. It is judges, local judges, state judges, federal judges, especially these days, who are making decisions about what those words exactly mean. What does peaceable assembly mean? What are the limits of that? And we know that because of judges wrestling with these issues for 238 years, there are limits on the First Amendment. Those people who say to you, Jim, I've got First Amendment rights, I've got fill-in-the-blank rights, the answer is yes, you do. There's not a single commitment of a right in the Constitution that is unconditional. Give me the right, I'll tell you what the condition is. And those are all products of judges who had to wrestle with what this means. What is the limit of being able to speak publicly, even to redress grievances in front of your government? What is the limit? A lot of focus these days in the Supreme Court, obviously, on religious liberty and establishment of religion. Where are those lines drawn? Those decisions have always been made for us after contest, after the cauldron, if you will, of litigation, principally civil litigation, sometimes criminal litigation as well, by judges, sometimes juries, who wrestle with these very difficult issues and define for a moment, maybe for a long period of time, what that language means. Do not in any way diminish the significance of those people that we elect to the judiciary, people who are appointed in the federal system to serve as federal district court and appellate court judges on the Supreme Court. They, to my mind, enforce the language of this Constitution.
Go ahead. No, you go. Well, I was going to say, I have a good segue to that, because when I was considering this question, I was thinking about how in my role as a judge, I have to grapple with issues pertaining to the First Amendment on a daily basis. And just as Jim said, the First Amendment right to free speech is not plenary. There are limitations. And so one example is I have to review petitions for temporary restraining orders that would ultimately lead to potentially an injunction, which is basically like a no contact order issued against someone. And so sometimes there's very clear cut cases. Yep, physical abuse occurred, I'm going to order this injunction. But when the allegations relate to threats, that is where I have to engage in this First Amendment analysis. There's a case, U.S. Supreme Court, that guides my decision, the Counterman case, and then there was a Wisconsin Supreme Court decision that had to grapple with this issue. But I have to sit there and analyze, well, is this a true threat, right? And so there's all the practicalities then of kind of grappling with that of, okay, am I going to grant this person's request for a temporary restraining order, or am I going to deny it? And then on a practical level, what happens, right, if something, that person goes out and then kills this person or something? So it's just an example on an everyday basis of how I'm dealing with the First Amendment. So there's a baseline, right? There are some limitations. I'm not advocating for more limitations on free speech, but what I also focused on was the second part of that question, which is what responsibilities should accompany that freedom if a democracy is to remain healthy? And that's where I think of, yes, let's call it a plug for Brookfield Academy. And I can do that. I'm on the board. The golden rule that we espouse that here at Brookfield Academy, of course, very widely espoused Judeo-Christian principle. But do unto others as you would have them do unto you. And that's how I believe that, yes, there's this free speech, but as responsible citizens, we need to be mindful of how we handle that freedom, because, you know, and I know from being a public figure that something that I can do can be interpreted differently, and a whole different narrative can play out. And we certainly see it, you know, friends, family, who we know that there are these just mass attacks against them based on, you know, something that they've done, and that can just simply ruin somebody. So we don't have to further, you know, curtail free speech from a government perspective, but we have to be responsible citizens.
Excuse me, I hate to interrupt, but we have to move on to the next question. We're over 10 minutes.
Okay.
I agree with everybody.
Well said, well spoken.
They're such intelligent.
Best answer.
Okay, so the next question is, founders such as James Madison and Thomas Jefferson emphasized balancing individual liberty with social order. How should that balance guide political debate and civic life in today's polarized environment?
Before you start, I guess when it gets to the 2-minute mark, 2 minutes till the 10-minute mark, wave my hand.
Jump up and down.
So we gotta go, so lightning round.
It's a question of enforcement.
And there are the judges right there, right?
Yeah.
All right.
Yeah.
Okay, well, the one thing I was gonna say about the previous question, and I guess it connects to this question too, is I teach a lot of First Amendment problem sets, so my students are doing a lot of, they're writing briefs and they're doing oral arguments, and often those are set in the First Amendment. And what I've come to really appreciate about the First Amendment is, to the points that everybody has made, is number one, how important it is when you read the facts of the cases, what people really have gone through, to express their First Amendment rights, and how complicated it is. The First Amendment law, would you guys agree, is very complicated. And I mean, really, you can really trace all sorts of, swirling eddies and trajectories in it. So I just wanted to emphasize the points that were made here about how it's not a simple thing. At the same time, my mom grew up in, she was born at the beginning of World War II in Hungary. And then she lived in Hungary through 1956 when she snuck out of the country and came here in communist Hungary, where she had no freedom of expression. And growing up in that home really made me, with my mom and my grandparents, really made me appreciate the fact that what protects us from that type of tyranny in many ways is our First Amendment rights. And I guess my one answer I was going to highlight is just that how much the founders were influenced by the Enlightenment, and going back even further to Aristotle and notions of happiness, that they really felt under those Enlightenment ideals that free press prevented tyranny. So I guess, and maintained democratic governance. So I do really think, what separates us from, let's say, tyranny that we see in other countries is our free press and our right to free speech, even if it's complicated.
I'm gonna shut up on this one.
Okay, well, so I'm gonna go, but I'm gonna be uncharacteristically brief. No, I think one thing it's important for all of us to remember is the Constitution is not a suicide pact, okay? Because this question is really about law, or about order versus liberty, and it's not a suicide pact. When you have to decide when to impose some more order and dial back on the liberty, I think of the quote from Justice Potter Stewart in 1964 when he was asked to define hardcore pornography, and he said, "Well, I know it when I see it." It's kind of a cop-out, but like when to adjust the order in law, you kind of know when you see it. I'm going to give you two concrete examples, and then I'm going to pass the microphone, so to speak. One, Abraham Lincoln at the beginning of the Civil War, he suspended habeas corpus, and he imprisoned many suspected Confederate sympathizers because he thought the country was in danger. Was that the right thing to do as far as liberty versus order? Most people would probably grimace and say, yes, oof. But contrast that with Woodrow Wilson, for example. Not one of my favorite people. If you know about Woodrow Wilson, giant racist and a little bit of a fascist. And he, during when he was president, he used the Sedition Act of 1918 and the Espionage Act to close down almost 500 newspapers and publications. He tried to prosecute about 6 newspaper editors. And to bring it close to home, he actually sent his administration against the Assistant Secretary of State for the state of Wisconsin, Lewis Nagley, in 1917, and they prosecuted him and threw him in jail for 2.5 years because our Assistant Secretary of State deigned to criticize a fundraising effort by the American Red Cross. He said the American Red Cross was, quote, no good, and that they were using the money for improper purposes, and that got him sent to jail under the Woodrow Wilson administration for 2.5 years. Is that too far? I would say so. So it's a little bit of trial and error, and we're going to stumble through it.
Identifying the question again, the word social order. I suspect every single person in this room has been in Washington, D.C., and you walk down Pennsylvania Avenue, and although you probably did not go inside, you walk past a building, a 1935 construction called the U.S. Department of Justice. It's now the RFK building. And over the main entrance to Main Justice, as it is called, inscribed in the granite, there are these words: before justice can exist in the conduct and the conscience of a government, it must first reside in the hearts and the souls of its citizens. Repeat that. Before justice can exist in the conduct and the conscience of a government, it must first reside in the hearts and the souls of its citizens. That's the connection between government operation, yes, enforcement, balanced enforcement, we'd hope, and the social order. It should all derive from you. I'm not telling you anything you don't know, but look at the Department of Justice. There are wonderful things written, inscribed on all sides of it, but that one is important. Again, the main entrance, and establishes the fact that everything goes on inside that building, and the federal building down the street, the Pyramid Building, and that big white palace on Capitol Hill called the Supreme Court Building. All of that derives from the social order of the people themselves. That's where it all comes from.
Does anybody have anything else to add?
I'm out.
No,
Okay.
because the 2 minutes.
Yeah, well, you guys are keeping us on task here, right?
We'll get caught up here. Okay, so the next question. Over time, many civil rights protections have been shaped through amendments and decisions by the Supreme Court of the United States. At what point does constitutional evolution remain faithful to the founders' principles, and when might it become reinterpretation?
Oh my gosh.
How much time do you have?
Oh my gosh.
Somebody else want to
Oh
go
my God.
first? You want to go?
Sure.
You go.
Oh, you go.
Well, so I broke this question down because it talks about both amendments to the Constitution and then Supreme Court decisions, and whether both of those constitute involvement in constitutional evolution and remaining faithful to the founders' principles. My position is that anytime there's an amendment to the Constitution, whatever that amendment is, it's remaining faithful to the founders' principles, because that was the way in which the Constitution was to be changed. And so, we've seen a number of amendments. Some amendments passed and then repealed, right? Prohibition. But that is the way the founders envisioned changing the Constitution. The problem is that to amend the Constitution, it's very, very difficult. Two-part process, it's very hard. And Justice Antonin Scalia, who I mentioned earlier, his one criticism against the Constitution, or he said the one thing that he would change is how difficult it is to amend the Constitution. his position is he'd make it a little bit easier. The problem is when it's so difficult to amend the Constitution, that's when you then have to rely on the U.S. Supreme Court. And I think that's when you start seeing more criticism of the justices engaging in judicial activism, because they're trying to match the Constitution to maybe the modern principles. And so one thing that I learned when I was taking constitutional law was the concept of stare decisis, so to stand by the things decided. And when I first learned of that, I was appalled, because I thought, as a constitutional scholar and as a lawyer and possibly a judge, every time that I had to interpret the Constitution, I thought, well, I have the right to go straight to the text of the Constitution and interpret it. But you learn that constitutional law requires that as soon as that amendment or provision of the Constitution is interpreted in case law, it starts to build cases upon cases upon cases. And so now in my day-to-day practice as a judge, if I'm determining whether the Fourth Amendment has been violated, maybe this is shameful, I'm not really going to the text of the Constitution, the Fourth Amendment. I'm going to the cases, and I'm following what the cases say, whether you agree with it or not. And so there's certainly benefits of this stare decisis. You have to have consistency. This is how this provision or amendment has been interpreted, and we need to know that this is how it's going to be interpreted moving forward. But there is this doctrine of stare decisis that says, well, but it's not absolute, and in certain circumstances, you can veer from that and you can overturn Supreme Court precedent, which is, of course, what we saw in the Dobbs case with abortion. And so, to summarize, we have these checks and balances in place with the Supreme Court, but because it's so hard to amend the Constitution, I think that's where we lead to some of potentially that judicial activism.
I'd like to, really well said, dovetail on what you're saying, because I have a little example on this. I don't know if anybody in this room is a fan of Justice Ruth Bader Ginsburg, but she became very popular, as a pop culture figure and as a legal scholar and justice. And when before she was a justice, she was a law professor at Rutgers. She did a couple of different things, but she actually, to Judge Davis's point, recognizing how difficult it is to amend the Constitution, she brought a series of cases, or she was part of a series of cases where she argued before the U.S. Supreme Court, and her whole focus of these cases related to gender issues, gender discrimination issues, was to try to obtain strict scrutiny review on the basis of gender. So if you're, a woman and you feel like you've been treated unfairly, or you're a man, she had cases like that too, who felt that they were treated unfairly or he was treated unfairly, that would be reviewed by a court very closely on strict scrutiny. And her whole purpose in bringing those cases was to try to get that into the law, because it is difficult to, we didn't ratify the Equal Rights Amendment. So that's an example of that. And then I just have a couple, reading assignments for you if you're interested.
Oh, no.
I just finished reading a book called The Brethren, and for those of you who are lawyers, or maybe you've read the book already, I'm late to the game because it's a fairly old book now. But it talks about the transition from the Warren Court, which a very activist court, to the Berger Court, which was somewhat activist as well. You learn that a lot of law, Supreme Court law, is made in the dialogue and discourse among the justices, and getting each other to agree, trading votes, et cetera. It's a really interesting book and gives you tremendous practical insight into how the U.S. Supreme Court operates. And a couple of other reading sources, if you want to know about the thought process behind the idea that the Constitution can evolve, this living Constitution principle. There's a law professor named Akhil Amar who has written about that. His writing is a little bit dense, but he's a really good source on this idea of the living Constitution, that the Constitution can evolve. On the other end of the spectrum are the originalists and the textualists. And if you want a really nicely stated resource, I would read Judge Diane Sykes, who is from Milwaukee, gave a presentation at the Cato Institute some years ago on minimalism. So if you remember Sykes, S-Y-K-E-S, and minimalism, you can find it very easily online, and it'll just take you a couple of minutes to read. And she gives a really persuasive view on originalism and the idea of really just sticking to the document, to the Constitution as a document. So those were my ideas for reading.
Those are good reading assignments. I thought you were going to assign us a bunch of cases to read and get back to you with memos.
Yeah.
No, that was good. Okay.
The 2-page farewell address myself.
Oh yeah, right. That I could handle. I'll go. So I wanted to jump on what you had mentioned, because it really is
Tyranny.
This is the fundamental debate. Really is, and we're not going to be able to resolve it anytime soon. Is the whole thing is like, is it a living constitution? Does it evolve? And you can see one side says, well, I mean, it's so radically different than it was years ago. We've got to evolve and change how we look at these things. And other people are like, well, no, some of these ideas are constant and they follow through. And the job of the judge is to say what the law is, not what the law should be. And we've got to make sure that we don't turn the courts into a second legislature, because that's not what they're supposed to be doing. So that debate continues. And again, one of the examples I mentioned earlier that you can study and you can see this go back and forth with the pendulum, so nobody's happy, is the whole idea of the 1930s and what started then with the larger federal government and the more power being given to the bureaucracy from Congress and other things, and then how it's kind of swinging back the other way. So you can see this change over time. I'm not actually so sorry that it's hard to amend the Constitution. There are a lot of bad ideas out there, a lot of good ideas too. So I don't think that's the worst thing in the world, but we're stumbling through it.
With all respect to Scalia.
Well, yeah, he's a pretty smart guy, yeah, but
Make it a little easier, I think.
I think my thoughts on this, I got 30 seconds.
Yeah, sorry, we didn't say.
Thank you very much.
You go first.
This is what I actually was thinking a lot about this week. Well, I don't know when it goes from evolution to reinterpretation. All I know is Jefferson hated Marbury. Jefferson hated that decision. He thought it was radical, unconstitutional, and Marshall, he always used the phrase, Marshall always makes a federal case out of everything. So Jefferson in 1803 said the Marbury decision, the basis of all judicial review, was a radical reinterpretation of the meaning of the Constitution. That's straight out of the chute. I think another point I'm hearing is, I think there's an argument to be made. We've had two constitutions. The original and the 14th Amendment might be a whole new one, because we're talking about Reed versus Reed so I think it may very well be that the 14th Amendment has generated a lot of heat. A lot of heat. So I think the 14th Amendment certainly could fit in that category, reinterpretation. Now the better question to me is it consistent with founding principles? I think that's a fair discussion, whether the 14th Amendment is rooted in the founding or not. Now, judicial interpretation of it's a different issue, but I think the 14th Amendment certainly, I think, would fit that category. Is it a radical reinterpretation? It's certainly, because it upends the whole federal system. No state shall is early in the 14th, section 1. So I think there are these points where it seems to me you got to give it 100 years before you really know if it was a radical reinterpretation or not. I mean, that's the historian in me, ducking the real question. So
I gotta cut it off.
I know.
That was good. Okay, last question.
Oh yes, final question. The founders wrote the Constitution in a world without mass media, social networks, or digital surveillance. As we reflect on these past 250 years, how should constitutional protections, especially speech and privacy, adapt to modern technology while remaining true to the nation's founding ideals?
Please start us out, Jim.
All right.
Yeah.
I'm going to jump back to the previous question, which I know is going to drive you nuts, but just wanted to offer one more illustration.
I object.
All right, then all my great panelists have.
Overruled.
have understood.
Darn it.
Jim Santelle is out of control. So, Sixth Amendment of the Constitution, it establishes all of these procedural rights in criminal prosecutions. Once again, you should know that prosecutors in 2026, years before, spend days, every single hour of every day thinking about those principles. It is not inapplicable. It is not just historical. And so, here's another prop that I brought along. Okay, this is something when I was U.S. Attorney, I gave this to every assistant U.S. Attorney who's starting in the office as a commission to what you do under the Sixth Amendment. And the point of this is a statement from Justice Sutherland in a case called Berger versus United States in 1935. And he talks about the role of prosecutors, strong blows but not unfair blows. Anytime that justice is done, the prosecution wins. It's a wonderful quote, a commission. My point in bringing it to your attention is that this case, under the Sixth Amendment, was a product of the question of whether or not criminal defendants have a right to discovery, have a right to know what the government is going to present to them in trial. Today, every single one of you knows this well. Of course you do. And cases are dismissed if the government does not do that. That was a novel principle in 1935, just beyond the lifetimes of everyone here, and it remains so very vital today, but it was novel then, and it is interpreted, again, not just this quote, but every single day when it comes to judges making decisions about what the Sixth Amendment means when it comes to representation, right to counsel, right to confront witnesses, all those kinds of things. And you know what? After Berger here, there will be more statements. There is more out there that comments upon what the Sixth Amendment, again, years and years ago, means today. I will also just make the other point, to partially answer the question. I already made the comments, right? And we know this to be the fact. I think I may have heard a train go by. And again, there are stoplights outside. We are right here in the middle of a room that does not have a fireplace or people fanning us. All of these things that would be right, there we go, right? That would be foreign to the people who wrote this Constitution. And so while I do not have a specific commission about what that means, just know, to the point that Melissa, I believe, was implicitly making, my own view is that it has to be a living Constitution, because the issues that you're raising in this question about things like TikTok and Twitter and the trial again that happened in Los Angeles a couple of weeks ago, all of those things virtually unimaginable by these folks and by others. And so necessarily, if you were to ask any of these folks about these issues, they would not know where to begin. And so the principles have got to be evolving. They've got to be evolving with respect to Sixth Amendment discovery and all the other technological issues with which we wrestle on a daily basis.
Nice. I think the court now uses this theory, text, history, and tradition. I think that came out of a New York case here about, I think maybe 7 or 8 years ago now. I mean, so I think there's an interesting thing in there where they're wrestling with how much does text matter, how much does history, and by that I think they mean the ratification, what they were interpreting it to mean. And then tradition is precedent. So it seems to me it's interesting that the court is using this framework now, text, history, and tradition. Now that opens up a can of worms, like I mean, are the founders Federalist or are they anti-Federalist founders? I mean, there's all kinds of cans of worms even in that attempt to use a framework to interpret. But I find it interesting that it's a combination of things that they're trying to sort through to use to reach reasoned conclusions now.
Okay. So, the question, part of the question is about technology, and I'm going to talk about free speech. And there's a really, really big thing that is starting to develop that people are starting to focus on now. And this is actually one of my better points, so this is good. But
So listen, we were.
so you have no idea where this is going. But no, if I took my phone right here in the United States of America and I posted something on social media, like on X, that goes globally, okay? So if I were criticizing somebody in Europe or some group in Europe or a bureaucrat in Europe or whatever, and I'm in the United States and it goes over there, I might have violated a free speech rule in Europe, maybe even a hate speech rule. And so Europe is starting to notice this right now. And the bureaucrats over there do not like it. So they are taking steps to crack down on X and some of these other platforms so that some of this can be curtailed, and so there's some senses of reasonableness to cut back speech. So the question is going to be, and it's going to be a big deal, how do we maintain free speech for American citizens on these platforms that go globally? How can we reconcile these rules? And there are going to be a lot of fights and a lot of stress, and it's going to be fascinating how that comes out. That's going to be a big technology problem.
That's really interesting. I have a technology example. Thinking about the Fourth Amendment and technology. So the Fourth Amendment, you know what that is. Really, the core of the Fourth Amendment, though, is privacy. You know, your right to privacy. So it used to be that when you, and that law is still true, that case law, you know, you do a bank card transaction. You have divulged your private information about what you just purchased on your credit card to a third party. You've released it to the world. Well, a few years ago, my students had a fact pattern that they were working on that was tracking a case called Carpenter versus United States. And the question in that case was whether when you take your phone around, you know, your phone can track exactly that you are in this room at Brookfield Academy, and then you walk to a different room. And so the question was, could the government access that information from cell phone tower record, from cell phone towers pinging, without a warrant? Because the Fourth Amendment requires a warrant unless there's an exception. And every single federal court of appeals that had looked at that issue, and there were many of them, sided with the US government. And my students were working on it. They were studying this problem, and half of my students were representing the fictional defendant, and half of them were representing the government. And the government people were so excited because they had all these cases in their favor. The defense counsel, they were really scared. They were like, what are we going to argue? And I said, well, we're going to work on some arguments. The case went up to the US Supreme Court, and my students were just flabbergasted when the defense won. But the reason why the defendants won, and Carpenter was so important in terms of its effect on Fourth Amendment jurisprudence and technology, is that it broke tradition with this idea that if you give your data to a third party, that you have relinquished your privacy. Because they said, with a lot of technology, you are automatically giving your data. You're not saying, maybe you signed a contract that you didn't even read so when you bought your phone or whatever. But I thought that was really important and a very interesting, pivotal point in American Fourth Amendment jurisprudence.
And if I can just reaffirm the concept that Melissa's presenting here, I am old enough to remember a time when we were sitting in the U.S. Attorney's office and wondering, pagers, right, and flip phones, and wondering how we can get the information here. And there was nothing written out there yet on it. That is how old I am. And we began to do things on the assumption that our arguments were right. They were tested in the courts, exactly the kind of thing that Melissa was just describing. That happened in my lifetime. And we began to think, and many other things, differences in all kinds of technological things that we engage in are quite literally debated every day in prosecution offices in this country, and they should be. And eventually, again, judges, Supreme Court judges and trial judges should in fact wrestle with these issues and tell us what the law is, so that when it comes to getting Jim Santelle's information from this, that the government does it right.
Yeah, so
segue to what Melissa was saying is what's presently pending before the U.S. Supreme Court is sort of the sequel to Carpenter, and it relates to the constitutionality of geofence warrants. And so as a judge, and this is why I'm sitting here right now with my bag and my phone, I'm on call right now. I've been on call for a week, where I'm on call from 5 p.m. To 8 a.m. where I'm reviewing warrants, right? And so that's part of my role as a judge, is I have to review the warrants, make sure that they're constitutional, and so I'm working with law enforcement, I sign them, I send them back. One of the warrants that I sometimes am asked to review is a geofence warrant, and what that is, it's building on what you talked about, is law enforcement have used a geofence warrant as an investigative means of determining who is in a particular area surrounding a certain mile radius of the scene of the crime. And so what they're trying to do is they're ordering, so I'm signing an order for technology companies like Google to provide the location data of every user within a certain mile radius of, let's say, the homicide scene. And the cops use that information because if they know that the alleged suspect then committed another offense, let's say 20 miles apart, and they get data from ranging in that area, and then they cross-check, and if they see the same phone number, they can go, ooh, this person was in that area at the time of the alleged crimes, and that's how they make their deductions. The constitutionality of the geofence warrant is being challenged, though, because it's retrieving information of so many innocent people who are not suspected of a crime who just happen to be in that area. The federal circuits are split in this regard, so it would be a good mock trial problem. And so it's just an example of reasonable minds differing, right, on whether this is constitutional or not, and we'll hopefully soon have a decision. But that is how we get new technology, it gets implemented, and then it gets tested, right, in the crucible of litigation.
All we have time for.
Defense of the Constitution rests. Pay your taxes.
Our founding documents, including the Declaration of Independence, are tragically considered by many to be obsolete and no longer applicable to modern day times. What many fail to understand is that they were instrumental in shaping our country as it is today. As our nation progresses, it becomes ever more important to educate ourselves about these pillars of the country, especially as so many across the nation become more democratically disillusioned. Doing so will serve to both better ourselves and this country for the next 250 years and beyond. Thank you so much, and that is the conclusion of this seminar. On a final note, we would like to graciously thank all of you panelists for taking the time to insightfully and thoughtfully answer each question. There is so much value found in listening to others, especially those as qualified as you. Thank you everybody for coming and enjoying this presentation.
I know, I'm pretty sure I didn't miss anything.
That's fantastic.
Thank you so much for coming. Thank you so much, panelists. This was wonderful.
Excellent.
We do have a report on the